Hello, my dear students. This is Dr. Kityagi, and today in this labor law second paper, we'll discuss the Employees Compensation Act 1923, which is given in your syllabus unit number 4, and this is video lecture number 31. And in this video lecture, I will discuss about the definitions and the extent and the commencement of the act, and certain important definitions we'll discuss. So, my dear students, first of all, we'll talk about the extent and the commencement of this act, the Employees Compensation Act 1923. And under section 1, it is given that this act may be called as the Employees Compensation Act 1923. And this act extends to the whole of India, and it shall come into force on 1st day of July 1924. Now we discuss about the certain important definitions given under section 2, subsection 1, and under different clauses. So the definition for a dependent is given under section 2.1, under section 2, subsection 1 and clause D, and where dependent means any of the following relatives of the deceased workman, because we all are aware that this compensation act is meant that in case of any mishappening with the employee, and if there is a fatal accident and the employee dies, then who will get that compensation? So the dependents are entitled to receive those compensations, and under this section 2 of the Act, subsection 1, clause D, the definition of the dependent is given. And here dependent means any of the following relatives of a deceased employee, namely a widow, a minor. This is clause subclause given under subclauses, and a widow, a minor, legitimate or adopted son, or unmarried legitimate or adopted daughter, or a widowed mother. So all these will fall in the category of the dependent one. I repeat, a widow, a minor, legitimate or adopted son, and unmarried legitimate or adopted daughter, or a widowed mother. And if wholly dependent on the earnings of the employee at the time of that deceased employee, a daughter or a son who have attained the age of 18 years and who is infirm, will be also treated as a dependent person. And if wholly or in part dependent on the earnings of the workman or the employee at the time of his death, then in this case, if the wholly or in part dependent on the earning of the employee at the time of his or her death, then a widower, in that case, a widower means a parent other than a widowed mother, will be also included in the dependent, and a minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if married and a minor, or if widowed and a minor. And a minor brother or an unmarried sister or a widowed sister is also a minor. Means if a minor, so a minor brother or an unmarried sister or a widowed sister. If the widowed sister is a minor, then they will also be treated as a dependent person. A widowed daughter-in-law, a minor child of a predeceased son, a minor child of a predeceased daughter, where no parent of the child is alive. I repeat this. This is given under this clause G, that a minor child of a predeceased daughter where no parent of the child is alive, and a parental grandparent if no parent of the employee is alive. Because see, if the parent is alive, then means they can take care of the grandparents. But in that means if means the deceased workman is having the parental grandparents, then they will be also, and they are alive, they will be also treated as a dependent person. So these are certain persons or the close relatives which will be treated as a dependent person for the purpose of this Employees Compensation Act. And here one explanation is also giving that for the purpose of clause, subclause second, as I told you, that subclause second was if, wholly dependent, you can refer subclause second, that if wholly dependent on the earnings of the workman at the time of the death, a son or a daughter who has attained the age of 18 years and who is infirm, then in for this subclause and item F, as means the we have referred this F clause F, that a minor child of a predeceased son, and G subclause also a minor child of a predeceased daughter. Subclause F uh, means we have referred the F and G of subclause third, right? So G is a minor child of a predeceased daughter where no parent of the child is alive. So references to a son, daughter, or child include a adopted son, daughter, or a child respectively. So these all will be included to this. So this is the definition given for dependent. And now we refer to the definition of the employer, uh, or before that we can discuss about the definition of the employee also under section 2(1) uh, clause double D, that employee means a person who is a railway servant as defined in section 34 of section 2 of the Railways Act 1989, not a permanently employed in any administrative district or subdivisional office of a railway. And this is subclause first for the definition of employee. And in subclause second, a master, seaman or other members of a crew of a ship, a captain or other member of the crew of an aircraft. And clause C, subclause C, that a person, item C is given there, that a person recruited as driver, helper, mechanic, cleaner, or in any other capacity in connection with the motor vehicle. So this is the definition given for the employee under section 2(1) clause double D. Now we refer to the definition of employer, which is given under section 2 subsection 1 clause E, that employer includes anybody of persons, whether incorporated or not, and any managing agent of an employer and the legal representative of a deceased employer. And when the services of an employee are temporarily lent on hire to another person by the person with whom the employee has entered into a contract of service for apprenticeship, means such other persons while the employee is working for him. So this is the definition given for the employer under this section 2 subsection 1 clause E. And managing definition for managing agent is also given under the act, that managing agent means any person appointed or acting as the representative of other person for the purpose of carrying on such other person trade or businesses, but does not include an individual manager subordinate to the employer. So this definition is also given. And for the purpose of this act, definition of partial disablement is also given under section 2(1)G, which describes that where the disablement is of a temporary nature, which means such disablement as reduces the earning capacity of the employee in any employment in which he has engaged at the time of the accident, resulting in the disablement. So the partial temporary disablement, which reduces the earning capacity of the employee in any employment in which he was engaged at the time of the accident, resulting in the disablement, and where the disablement is of a permanent nature, and such disablement as reduces his earning capacity in every employment which he was capable of undertaking at that time. So this would be treated as a partial disablement. So these are the certain important definitions given under section 2, subsection 1 under different clauses. And then there is a important definition given under section 21L, and that is related to the total disablements, and which talks about the total disablement, whether temporary or permanent, and incapacitates an employee for all work which he was capable of performing at the time of accident resulting in such disablement. I repeat, my dear students, that section 2 subsection 1 clause L, that total disablement, whether temporary or permanent, incapacitates an employee for all work which he was capable of performing at the time of accident resulting in such disablement, will be treated as a uh, I beg your pardon, total disablement. So these are certain definitions given. Then the definition of the wages also given under section 2, uh, 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 2 subsection 1 clause M, that wages includes any privilege or benefit which is capable of being estimated in money other than a traveling allowance or the value. Means the traveling allowance will not be included in that, or the value of any traveling concession or contribution paid by the employer for a workman toward any pension or provident fund, or a sum paid to the workman to cover any special expenses entailed on him by the nature of his employment, will be taken into consideration. So as I told you, that other means the benefit which is capable of being estimated in money, and other than a traveling allowance or the value or any traveling concession contribution paid by the employer of a workman toward any pension or provident fund, or a sum paid to the workman to cover any special expense entailed by him nature of his employment. So these are the definitions, certain important definitions given under the, and you can go through with the help of Barrett also. Here, my dear students, I would like to emphasize on one important point apart from the definitions, that prior to passing of this act, there were certain defenses available to the employers, which employer used to take plea that I'm not liable to pay the compensation for the employee injury because he was proved guilty of negligence. So even when his negligence was proved, he could avoid the employer could avoid the liability by putting forward any of the following defenses. So the first defense of the employer was the doctrine of assumed risks, and the employer used to mention that this doctrine is derived from the rule voluntary non-fit injuria, which means where there is a consent, there is no injury. So the employee has consented to work. So the person has voluntarily agreed, right, and consented to take the risk of injury. So why should I pay? He has no remedy in law. And the other doctrine or the other defense was available to the employer was the doctrine of the common employment, and the doctrine provided that an employer is not liable for the payment of compensation to an employee for injury, provided if he is working with several persons for a common purpose and his injury, he was injured by some act or omission, some of the persons of his group. So why should I pay? So this was another plea available for the employer as a defense. And the other doctrine was, as a defense for the employer, was the doctrine of contributing negligence. And according to the common law rule of contributing negligence, an employee is not entitled to pay compensation for injury when means which has been caused to him by his own negligence. So the employer used to say that why should I pay for the negligence of the employer, right? So this was again one more defense available to the employer. And one more defense was available to the employer before passing of this act, that was end of personal action with death. An employer could also evade liability to pay compensation in case of a death of an employee on the ground that the personal action died with the death of the workman concerned, and hence the dependent of the deceased workman were not entitled to claim for compensation. So all the defenses were means exercised by the employer to prove to be very harsh for employees, and it was almost impossible for an employee to obtain any sort of compensation, any sort of relief in case of accident or fatal accidents. Then to overcome from all those things, the first act was passed as Fatal Accidents Act in 1855, and then there were Employers Liability Act 1938, and the Employees Compensation Act 1923 was enacted to meet the certain other important objectives to provide some sort of compensation to the employees, right? Uh, and because there were certain objections of the employers, so then this Employees Compensation Act 1923 came into picture. So this is all about for today's deliberation, my dear students. I believe certain important definitions you will refer with the help of the BEAR Act. And the prior to, or before the passing of the act, there were certain defenses available to the employers. You can just go through those defenses also. Thank you so much. Have a nice time. Thank you.